ask. So I do want to welcome everyone. My role as MC is to just go over some of the basic rules of the road. One, for people who may wish to have easy access to the signing interpreter, or the video screen that's putting up text of everything we're saying, you might want to move over to this side of the room, and if you can't find a seat that's helpful to you, wave, and one of my staff people who's here will help make sure you get the right kind of seat so that you can have full access to our event. We are trying to make sure that at all of our Senate events, we are as accessible as possible to people. And I have to say, the new technology allowing whatever gets sent to them directly to text, right farther down the other end, it's pretty amazing. Actually, I guess it's the second or third time we're using it. Also, just know there will be a question and answer time, and you were given index cards in the front when you came in, and you are welcome to wave at any point to hand in the card with your question on it, and or ask for more cards. We have a really big crowd here, so I don't know that we'll get to everyone's question. What we will try to do, just remember in your question, we will try to stay very focused on bigger policy issues that the legislative changes impacted, not individual personal issues for your housing situation. And the HCR commissioner won't be able to stay through the question and answer time, but she's already agreed questions that are specifically for HCR. We will give her at the after tonight, and she has offered to give written responses afterwards that we will put up on our website for everyone to see. We've now also been joined by Senator Brian Benjamin. And what sort of the lay of the land is, I want to make sure I covered the important thing. I, of course, want to thank the CUNY Graduate Center for letting us use this fabulous auditorium. You know, it's hard to find public space for 400 people in Manhattan, so it's great that the CUNY Graduate Center is geographically located right here in central Manhattan and is very willing to allow us as elected officials to use their space for important community meetings like this. So thank you, CUNY Graduate Center, if anybody's listening. And what is this whole event about? The changes we made in the new rent laws. We made significant new changes with new protections for regulated and market rate tenants. And you'll be hearing details by Ellen Davidson in her presentation. We closed numerous loopholes and new prohibitions on deregulating units, which will hopefully keep units affordable, lead to increased housing stability, and should be significantly decreased tenant harassment. I want to just highlight that the Senate held hearings throughout the state to hear about the local housing issues, and then held months of discussions under the leadership of Brian Kavanagh as our housing chair, and Delmer Myrie, who's a Brooklyn senator you might not know as well. But I really do want to give them the shout out of doing so much work to get us here. Of course, we couldn't have done it without our colleagues in the Assembly passing the exact same legislation. Changes don't come without the advocacy work done by tenants and tenant advocacy organizations around the state. And Delsenia Glover, who's here with us tonight, did an amazing job organizing and doing work through the Housing Justice for All Coalition. That was up in Albany constantly and showed the power of new organizing on a city like Albany and the state legislature. And I know the laws aren't perfect, and even tonight as we were walking in here, we were having a little bit of discussion of, did the law mean this, did it mean this? So I want you to know, speaking on behalf of Senate Democrats, we're really proud
engaged in this process with government about important issues such as housing and housing affordability. So I thank you all for being here. I thank Senator Krueger, Senator Benjamin, Senator Kavanagh, Senator Hoylman. These are all representatives who have been for a long time great advocates for affordable housing, and so not only am I appreciative for that as a housing commissioner, but also sort of personally, it's really important to be able to work with people who both understand the complexity and depth of these issues and also fight incredibly hard to make meaningful change. I would also thank Ellen and Delsenia for being here too. We couldn't be sort of better hands in the advocacy world than the two of them, so I'm sure they will have important things to share. I apologize in advance if some of the things I say may be duplicative to what other people say, but I get to go first, so I get to say them all. I know there has been a lot of uncertainty since the new laws went into effect in June, and I will try, in the course of my remarks, to maybe clarify some things as best that I can. It was a very comprehensive change, so I won't touch everything that happened in June, but I will cover as much as I can. And as Senator Krueger said, I can't stay for the Q&A, but my staff is ready to follow up questions that I can't answer today, and we will provide answers in writing. So let me just start by sort of stating the obvious. There are far too many New Yorkers who are burdened by skyrocketing rents and who live in unhealthy and unstable living conditions. And while the governor and the legislature have successfully advocated and passed laws to protect tenants in the past, it was very clear that there was a lot of work that remained to be done, and that was obviously the impetus for the Senate and the Assembly to pass the most sweeping rent reforms in the country. So the short version of why these reforms are important are: we are stopping the exit of units from the system. We are reducing the speed at which rent-regulated rents are rising. We are removing incentives that reward tenant turnover and that can often result in harassment. And we are ensuring that owners will still be able to maintain the quality of their properties through investment. So what has changed in order to allow that? I'll provide a couple of sort of comparisons between the old law and the new law. And as I go through this, please understand that there's a lot more to the laws than what I'm going to cover. We have a website, www.hcr.ny.gov, that has materials on it, and we will continue to be out in public at events like this and others to be able to talk to people about the changes. So I'll go through sort of the highlights of the big things that are most often talked about. So vacancy decontrol was repealed. Obviously, previously, landlords could permanently deregulate apartments that were not subject to tax benefits when they crossed a certain rent threshold. That was $2,744 a month, as many of you may know. Under the new law, the decontrol threshold has been eliminated, and landlords could no longer deregulate apartments due to high rent and high income. Vacancy increase, so there had been as many of you are aware from many of these things, there had been a 20% increase upon vacancy. There had also been a longevity increase in rents for tenants who were in occupancy for an extended period of time. Landlords can no longer increase legal rents they can only increase legal rents by increases as determined by the Rent Guidelines Board, and the longevity increase has been eliminated. Preferential rents. So landlords would choose to charge a tenant less than the legal registered rent, called a preferential rent. Due to changes in the law in 2003, as tenants renewed their leases, that rent could jump from a preferential rent to a legal rent, and these increases were obviously much greater than Rent Guidelines Board increases and were creating undue burden on tenants. So under the new law, preferential rents operate as the legal rent for the life of the tenancy, and it cannot jump to the legal rent at lease renewal. To be clear, if you paid a preferential rent on June 14th, 2019, you cannot have your rent increase to the legal limit at the next renewal. And we know some people may have signed a lease prior to June 14th that would have taken effect after June 14th, and those rents also cannot be raised from the preferential rent to the legal rent. They can only be raised by the Rent Guidelines Board. An owner can take a rent for an apartment from a preferential rent to the legal rent on tenant turnover, so as a new tenant comes into that apartment. Major capital improvements, landlords have been entitled to permanent legal rent increases for capital work that was performed building-wide, and the cap of that increase on a tenant's rent was 6%, so your rent could go up by a maximum of 6% per year to compensate for that major capital improvement work. So in the new law, the increase in the rent is no longer permanent, and the rent increase cap is lower. So specifically, increases in rent due to MCIs are limited to no schedule that HCR will create. Individual apartment improvements, so there's a lot of talk about individual apartment improvements done on vacancy. So IAIs, as they're called, can still be done with tenants' permission for tenants in occupancy. But the law changed and modified the impact of those rent increases as a result of IAI. So first, an IAI spending was capped at $50,000 over a 15-year period, and a landlord could do no more than 3 IAIs in that time frame. Increases are not permanent, just as with MCIs. After 30 years, from the date that the increase becomes effective, the IAI goes away, the IAI increase. And monthly IAI fees that are passed on to tenants are going to be lower because the formula changed. So the amortization period for IAIs was lengthened to 14 years for buildings with 35 units or less, and to 15 years for buildings with more than 35 units. A couple other important changes. No sunset of the law was established, so the new rent laws do not expire automatically as they previously. Also, municipalities that self-declare a housing emergency, so go through a process to demonstrate that there is a less than 5% vacancy in the rental housing stock can opt in. This law previously allowed municipalities in Nassau, Rockland, and Westchester to do that, and now that is statewide. And lastly, on rent overcharges, previously tenants could claim overcharges looking back in a 4-year window. The law now extends the look-back period to 6 years or more as reasonably necessary to determine a reliable base rent. So those are kind of some of the highlights of the big topics of things that are often talked about and sort of big changes that were in the law. In terms of how you might know about these things and how they sort of get transmitted, with the laws now in place, HCR has issued guidelines that are for both landlords and for tenants on how these laws are implemented. So just today, we have put up what's called Fact Sheet 26, which is a guide to rent increases for rent-stabilized apartments. You can find that on the HCR website. It provides renters and property owners with a better understanding of the details that I just talked you through, so you didn't need to take any notes before you get to our fact sheet. We also put up a fact sheet called Fact Sheet 40, which is a fact sheet about preferential rents. This helps tenants understand the rules governing lease renewals and preferential rents, and it helps owners understand their responsibilities and the steps that they have to follow as it relates to preferential rents. In addition to fact sheets, we also publish on our website advisory opinions, and also up on our website is a revised New York City lease rider, so all rent-stabilized tenants have a rent-stabilized lease rider. That form has been revised to now reflect the changes in the law, and the form of that is up on our website, as well as the standard lease addenda for those who reside in the ETPA, so in the counties of Westchester, Rockland, and Nassau that are subject to rent stabilization. And please know that should you read these documents and these forms and you still have questions, you can contact HCR. We have borough rent offices in downtown Brooklyn, in Harlem, in Lower Manhattan, in Jamaica, Queens, and in the Bronx. And our staff is there and ready to assist renters with any questions they may have. And lastly, I would just close to say I'm sort of thankful, as I always am when I get to speak publicly, to be able to thank my staff who has been working very diligently over the last couple of months to both understand sort of the depth and breadth of the law changes, to be able to put them into English so that people who reside in New York City's apartments can understand those in sort of an easily consumable way, and try our best through these first fact sheets. And there will be more fact sheets will continue to get posted throughout the month to address the other topics that I talked
It really is a great pleasure to be here. Thank you, first of all, to Senator Krueger for putting this event together tonight. And I do want to, a lot of acknowledgement and mutual thanks up here, but I do want to thank, all of my Senate colleagues, and particularly the senators here, Senator Benjamin, Senator Hoylman, and Senator Krueger really did make a huge priority of what we managed to accomplish this year in the housing area. It is great to have a commissioner who comes before you and is willing to present the great work that they're doing, and we are very heartened by the extent to which they have embraced this law and are already putting out kind of written directives that explain the rights and obligations of landlords and tenants. This bill happened very substantially because of a very long-term advocacy effort. So many of you in this room have been involved in that. Certainly, Tenants and Neighbors and Delsenia Glover have been an enormous part of that, and fighting over the course of many years when it was always an uphill battle. We had these laws being expired and needing to be renewed, and fighting tooth and nail for small changes. But the groundwork we laid over the course of many years is the reason we were able to get this huge step forward this year. Leslie, Ellen Davidson, who you'll hear from tonight, really legal aid, and particularly Ellen, really have been, they fight directly with tenants in the trenches and the courts, but also their expertise really did help shape this and get this law right and make it such that it really is going to affect people's lives in a very positive way. So we set out this year in many areas with a new majority in the Senate to rethink fundamentally lots of areas of law, but particularly housing this year. So this bill, the Housing Stability and Tenant Protection Act, in addition to the rent laws, also fundamentally changed the nature of a variety of aspects of landlord and tenant law. We changed the standards that are in place when people are facing eviction. We made it such that the landlord can only lend 1 month security deposit. We changed some of the rules about fees that tenants can pay upon application. There were 170,000 people who live in manufactured homes in New York. Most of them are not in New York City, but some are. We also set a whole new regulatory process for that. That's about a sixth as many people as our rent regulator. It's a big housing stock. And we changed a lot of the laws around conversions from rent-stabilized housing to co-ops, to co-ops and condos, because we thought that might be a way that many people who are currently dealing with rent-regulated housing might find a way to push tenants out. So we made it a lot tougher to do that and made it such that those deals can only be done if the people in place in those buildings want to see that happen. But there's a reason we focused on the rent laws in particular. And it is that for many, many years, the rent laws were the backbone of what made New York City, New York City. It is what allowed people to move into a community, settle in that community, maybe put their kids in the school, and expect that whether that community became fashionable or unfashionable, whether prices went up across the board, whatever happened in the economy, if you continue to pay that rent with reasonable increases, you can continue to live in that community. That fact, which was in place for many decades in the city, began to erode, initially slowly and then very rapidly over the last few years as the deregulation provisions were added to this law. Many of these provisions, as has already been mentioned, rewarded landlords for pushing people out of their homes. In many cases, people, because of the loopholes, apartments were more valuable vacant than occupied, and more valuable if you could push things toward these thresholds to deregulate them entirely. So we think that one of the things we've done is now reset a baseline where there is this enormous stock, 1 million apartments home to almost 2.5 million people that are the baseline affordable housing of New York. There are many other affordable housing programs, and the city, state, and federal government have all invested a lot of money in increasing the stock of affordable housing, but we have been losing ground over time because whatever we were doing on adding to supply, we were losing it as a stabilized stock. So we think this is a huge change. We'd like to do a lot of what we're doing tonight, which is get the word out to people, that people have new rights and new obligations. And there is, one of the things that I heard a lot was during the negotiations, but this is a once-in-a-lifetime opportunity. And we did treat it, many of us have in fact been fighting for this for a lifetime. But I don't think process to continue to make this a city where everybody is entitled to a decent, affordable place to live. What we've done in this law is a big step forward. There's a lot more work to do, so we look forward to continuing to hear your ideas about that. I want to thank you.
So we've also been joined by our colleague, Jose Serrano Jr. So welcome, Senator Serrano. I'm going to go in order with people who arrived. So Senator Hoylman, would you like to speak from there if you like, or from here, whichever. We'll just do
Liz has to tell me a couple of minutes, Senator Hoylman, because she knows I might go on too long, but you're right. I just want to thank Senator Krueger for hosting tonight's event, and our colleagues who are up here, Senator Benjamin, Senator Kavanagh, Senator Serrano, Senator Jackson, who I know is going to be joining us shortly, and the advocates. Delsenia Glover from Tenants and Neighbors deserves a great amount of credit for advocacy, as Connie Davis for her expertise. The combination, I'm telling you, it was a combination of advocacy and expertise that really made the Tenants Protection Act possible. I know that for the first time in Albany, we have broken the landlord lobby. That's a big deal, folks. Let me urge you, some of us were late getting here because downtown today there was testimony about instituting a system of public financing of our elections. That's the next hurdle that we face as tenants and neighbors to ensure that the voice of the average tenant, the middle-class New Yorker, and the citizen who desires to participate in our electoral process is heard. So I urge you to continue to fight for public financing of elections, to continue with fusion voting, another plug, and to thank my colleagues. And in particular, I want to say something, I think I'm at 1 minute and 45 seconds. Senator Kavanagh held hearings 5 across the state of New York, and all of my colleagues at different points in time attended those. We heard you. The Tenant Protection Act is a result of your voice, and now we will listen further. And as Senator Kavanagh said, our work is not done. And in fact, just this past weekend, we convinced a big landlord in my district, Blackstone Realty, to stop warehousing apartments and make certain that every New Yorker has the benefit of these new rent laws. So thank you very much for your activism. Thank you to my constituents, and thank you, Senator Krueger.
I will break the trend and I'll stay at my seat. Well, first of all, good evening, everyone. Thank you all for coming. First, I want to also commend Senator Kavanagh for just not only did we have all those hearings, but we had at least 2 working groups, a working group and a second working group. We spent countless hours on this topic. I cannot tell you how organized and effective the grassroots effort was. I think I got an email, call, and text from Delsenia Glover at least twice a day. And by the way, it's one thing to get called, emailed, and texted. It's another thing when someone knows exactly what they're talking about. They know every single piece of the bill, every platform, and can go argue with you for hours on end about all the nuances and help you understand every piece of everything you're looking at. And so I just want to say to all of the activists, Housing Justice for All, tenants and neighbors, everyone who was involved in this, job well done. This should be a case study about how you actually get bills passed based on the effort that was put forward to get rent reform done in New York City. New York State, I apologize. I just want to, Liz, if you don't mind, I want to commend you as well for just being a consummate senator. I know there's a big push for term limits and elections. I just don't want it to apply to Liz Krueger. She should stay in office for as long as she one quick thing. One of the bills that was part of this omnibus was passing a bill to change how rent control departments are treated. There's about 21,000 or so rent control departments that are not as many as the million rent stabilized apartments. But these are people who have lived in their apartments continuously since 1971, and the buildings were constructed before 1947. So it was a small population, but as you can imagine, a population that is very vulnerable to rent increases. And the way their rent was determined was based on a maximum base rent system, which if anyone who is a scholar in housing understands how the maximum base rent system works, I would love to get their resume, because this was the most complicated thing I've ever seen in my life. But what it ultimately ended up in was that rent would grow annually 7.5%. And I don't know any senior living on fixed income whose assets, Social Security or anything's growing fast enough to pay for that. So a very vulnerable population. We were able to change those laws so that their rents will not grow at 7.5% annually, but will grow at the average of the last 5 years of the Rent Guidelines Board increases, which would be more in the 1% range, etc. And they also used to have fuel pack. Oh yeah, please clap for that. I'm excited about it. It's not going to be controlled and everything else, but I liked it. And also the passive fuel cost pass-alongs. I don't even know where that came from. We got rid of that as well, and so there are 20,000+ folks who live in rent-controlled apartments who now can rest easy at night knowing that we passed a bill to rationalize how their rents are being determined. So all the amazing things we did, I just want to put a plug for that as well, because it's so important that we make sure that people who have lived in New York City and New York State and who have paid their dues and just want to have a nice apartment with some dignity don't get constantly bombarded with incredible rent increases. Thank you.
Thank you. And I think Robert Jackson is going to come in a little later, and I'm very trying to shut him up. You know that's not possible. So we'll let him speak in 5 minutes. Thank you. Or he'll wait till the next presenter's over. So I have my colleague Serrano, Jose Serrano Jr. For those of us who are friends, call him Marco. So I'm delighted to be all
But I just want to thank all of my colleagues. Pretty much everything has been said. I want to thank Senator Krueger and Senator Kavanagh and everyone who you see here, the activists, everyone in the audience, who are really making something happen that I think several years ago we thought was a pretty daunting task. I applaud everyone for having the courage to make this rent protection package a reality this year. And it really does go to show when you have the grassroots support, when you have all of the know-how and expertise, this is one of the things that create good things in our community. So I represent a very diverse community, the South and West Bronx, Roosevelt Island, East Harlem, Yorkville, Central Park, and the Upper West Side. So easily one of the most bizarrely drawn districts, but so wonderfully diverse and a great deal of rent control, rent stabilized apartments. And it's really important that we understand that the protections that we passed, yes, they do a lot to protect and to preserve affordability, but they also create stability within neighborhoods, which is something that is extremely important if you care about an economic model that supports continuity in communities and vice versa. So I think this is good business for New York City to have communities where folks can raise families, can lay down roots, can work, can do all the things that we need to have a thriving, diverse economy. And I think that that's part of this overall discussion of all the many reasons why the package of bills that we passed this year is so important. It's also important, I think, for the long-term economic stability of all sectors within New York. So I applaud, once again, all of my colleagues and for doing something to create the kind of affordability that we hope will last for generations. Thank you.
Thank you. I'm now going to turn it over to Delsenia Glover, who you already heard so many things about. In case you didn't already know her, she needs very little action. So, thank you, Delsenia.
Better on my feet. I feel like I should just come up here and say thank you and good night. I don't know what else to say. Everyone said it for me. But thank you, Senator Krueger, for putting together this forum. Very well done, as you always do. You have to always have the biggest crowds. And thanks to everybody on the panel, and thanks to all of you who, without your support, we wouldn't have been able to do what we do. I'm a big fan. I'm just going to tell a little quick story. I'm a big fan of Chris Rock. And this was back during the days of the Tea Party. These are the kinds of things that I think about that keep me up at night. So, this was back in the days of the Tea Party, and he did this HBO special. And he said he was trying to figure out and understand why these people were doing these things, these crash and burn things, and why they were just so crazy. And so he said, he thought about his children. And his children, whenever children behave the worst, it's either at bedtime or before a nap. And so he said he finally figured out that they're about to go to sleep. So when I think about the menace in the White House, I just think back to that and I say, he's about to go to sleep. I think about. So for those of you who may not know Tenants and Neighbors, we have two affiliate organizations, and our mission is to build a powerful and unified statewide organization that empowers and educates tenants, preserves affordable housing in rural neighborhoods and diverse communities, and strengthens tenant protections. So on the tenant protection front, I've been doing this work for a really long time, and I was just speaking to Senator Krueger, and we're like, are you still pinching yourself when you wake up? Yes, we're still pinching ourselves that we were able to get so much done for tenants this year. So I was asked to come tonight and talk about the importance of organizing the housing justice movement and where we go from here. I feel like the housing justice movement is sort of really coming into its own. Tenants have never had so much power before, and where it comes from is all of the organizing that we've been doing over many years, and then also expanding our movement beyond New York City statewide. Another thing that we've done is, working with different partners to do different things. So, and we've understood for a long time that the reason why we were not getting anything done was because everything was passed in the Assembly, and then it would get stuck in the Senate, because the majority of the people in the Senate were not our friends. Then, lo and behold, there were Democrats elected to the Senate, but they chose to become the independent Democratic caucus, and we still couldn't get anything done. So, lo and behold, we figured out how to do that. And the way that you do that is to mobilize and get them out of office. That's what we did. So the importance of organizing is organize power. And when you organize people power, what the people power have to do is have an effect on people who are elected officials to make a decision that is in our favor. And the way that you do that is with numbers. We had so many people from so many different areas and so many different kinds of justice movements all coming together to make a difference in one particular thing at a time. And that was housing justice. When folks, I'm not talking about these folks have always been our allies, but numbers affect elected officials because numbers mean votes. And so the reason why you organize is to show the power of the people and of the grassroots, and that is how you affect change. And I'm happy to hear Brad bring up the subject of public financing of elections, because that's another thing you have to, really get involved in. People power.
Yes.
So I'm not going to talk about what we did, because Ellen is going to get up and talk about that some more. But what I want to stress is that is the beginning of something. We have not finished the job. There's still a lot to be done. I do not want anyone to think that because we did so well this time with these laws, that it's time to sit. The real estate industry is already suing. And they are not going to go. They're not going to go down without a fight. So we have to stay vigilant and stay on our toes. Well, I was also asked, well, what's coming up for you guys? What are you looking at doing going down the road? So we are looking at various things that did not happen for us. One was good cause eviction. And so we are reimagining sort of our statewide platform and what we're going to be doing in the coming session and moving forward into the years ahead. And we've expanded our motto, I guess you would call it. And what we want is to preserve safe, dignified rental housing for all. And this is not just for people who live down here in the city, this is for folks all across the state. If you think it's been tough for people who live in rent-regulated housing, you have to educate yourselves about what's going on across the state. First of all, what we got is expansion of the Emergency Tenant Protection Act, which means that municipalities across the state can opt into rent stabilization. There are people who live in communities all across this state who have no rent regulation and they have no eviction protection. So they live in absolutely deplorable conditions and they're afraid to complain about it because their landlord can evict them without a good cause. And so this is one of the pieces of our platform that we will be beating and pounding vigorously coming up that session. I know a lot of elected officials probably say, look what we did for you all last time. You know, can we take a break? No. You cannot take a break. There's too many things left to do. There's also a true crisis in public housing. Folks who live in public housing, the whole system of public housing has been defunded over years. There's money that's been designated for public housing, millions and millions of dollars, that the governor, for example, has not released. So we are going to be supporting the fight for livable public housing. We want to eliminate major capital improvements. Now, the fix to major capital improvement is really quite simple. We want to eliminate the whole thing because we think that landlords required to take care of their buildings. Folks like to say that, landlords like to say that, oh well, there's this whole thing happening now. You see these articles out where they're saying, well, we're not going to be able to take care of our buildings. Oh crap. You will be able to take care of your buildings. You may not be able to buy a bigger yacht. You will be able to take care of your buildings. Nobody is into the business of being a landlord or a developer because it's a struggle. They get into that business because it pays very well. So don't believe it when people cry that they're going to be poor or you're going to have to live in deplorable conditions because they can't get an MCI or they can't get a vacancy bonus or an IAI. Landlords get paid. Another thing that we're looking at pushing forward is the re-regulation of units that have been deregulated. We've lost over the past 20 years, is it Ellen? Or 40 years maybe? Since 93, we've lost close to 400,000 units of rent-regulated housing. 400,000 units, that's 400,000 families, that's more than 1 million people. We need to re-regulate those units. Because if we don't, landlords have fixed black murder. They use the loopholes to push these apartments out of rent regulation that should not have been here in the first place, and we need them back in a city as big as this. We need them back, and we're going to get them back. We also want there to be some development of new affordable housing. We have a homelessness crisis in this city that is absolutely, I can't believe it. I remember when I was a little kid growing up, if there was a homeless person sleeping in a storefront on Madison Avenue and 65th Street, breaking news on Channel 7. It was a big deal. But now, it's like we walk past these people as if they're not there. The numbers are approaching 100,000 in this state, and it's escalated by 37% or more over the past 12 years. This is unconscionable. And most of these people are families with children, and we know what that does to children to not have a home. So we have a lot of work to do ahead. I want people to remember that we have become a movement, and to remember that we must stay a movement. We must stay organized, we must persevere, and we must keep going forward in a unified manner so that all people in this city, across this state, and across the country can live decently without fear of eviction and without fear of having to pay rent over getting medicine.
Hi everyone. I'm Robert Jackson. If you don't know me, I represent the 31st Senatorial District, which from Marble Hill, it comes all the way down into the Chelsea area, along with Brad. But the most important thing is that we're here, and you should know that without your help, this would have never happened. The blue wave came and said, woo! And now, as what Delsenia said, that the bottom line is there's going to be demands for more. Obviously, everybody wanted everything in the beginning. I wish that I could eat a whole watermelon by myself, but I can't initially. So you have to eat it in piecemeal. And so right now, next year we're going to be focused on many things that we have to correct because we did a lot of things fast, and some of them have to be adjusted. I'm not talking about housing, I'm talking about everything, you know? And I think that understanding, you should know that we have a clear majority in the state Senate. But the goal and objective is not what we have now. It's to bring some more so that we have a clear majority if in fact ever the governor should override a veto, we have enough to override a veto. That's what we have to do. And so with your help, with everyone's help, to make sure that happens. Because you know why? The governor, he's not stupid. He's smart. He knows right now we don't have enough to override a veto if he should ever veto it. So that's what we have to do. So our goal and objective is to win a couple more seats. I ask you, we need your help. So please help us do that. Thank you, everyone.
So now I'm going to hand it over to Ellen Davidson from the Legal Aid Society. Ellen has a PowerPoint. I believe there were materials up front that people got. Did they get copies of? Yes, okay, good. And as you've already heard, Ellen, as one of the attorneys for the Legal Aid Society, was basically loaned to the legislature to help us figure out the enormous number of technicalities that we were dealing with in trying to come up with a bill that I'd say was really a merger of more like pieces of 25 pieces of legislation that legislators have been working on over the years. So without any more intros, Ellen Davidson.
I did bring a PowerPoint because I do. I like PowerPoints. But before I started, someone reminded me, I've done a lot of these trainings, and in one of them I talked a little bit about what the law is. It's probably going to be important for some of the questions. We have 3 types of law And then the third type of law is what judges do, is that they interpret the law. Sometimes they decide that the regulations are wrong based on the language of the statute. But part of the reason I start by this saying is I expect to get a lot of questions tonight about how is this law going to be interpreted? What does this mean for me and my particular situation? And the chances are, for most of it, my answer is going to be, I do not know yet. You should make this or that argument. I think it's a good argument. But ultimately, how this law will end up being has not been written yet. Part of it is we're waiting for regulations, and part of it is we're waiting for the courts to give us the final word of how these words should be interpreted. And you'll see a really good example, breaking news, based on what the law says and how HCR is interpreting it and whether we think it's correct or not, or whether I think it's correct or not. So, deregulation. We talked about this briefly before June 2014, 2019. There were two types of deregulation. Both had to do with reaching a rent threshold. One had to do with reaching the rent threshold when the apartment was empty. The other one had to do with reaching a rent threshold when the apartment was occupied, but the household who was living in that apartment had an income of over a certain income threshold. And it used to be, if the apartment was empty and reached the rent threshold, the apartment could be deregulated. And if you were living in an apartment that was above the rent threshold and your household income for 2 years was $200,000 a year, your landlord could apply to HCR to deregulate those units. We talked a lot in our coalition about vacancy decontrol, but the truth is the legislature got rid of both types of decontrol. So rent-regulated apartments that come in through the Emergency Tenant Protection Act or the rent stabilization law can no longer be deregulated, either through a one group of apartments that can still be deregulated. So some apartments are regulated because the landlords get a tax abatement called 421A. Those are buildings built after 1974. If you have an affordable apartment in one of those buildings, it can never be deregulated. If you have a market rate unit in one of those buildings that was built after 2015 and received the 421A tax abatement after 2015, on vacancy, those units can be deregulated. I will point out that the 421A law, through some manipulations of various people, not on this stage, but in the government, it used to be that they were both, the 421A and the rent laws came up at the same time, but the real estate industry didn't like that, so they got those two issues delinked. So the rent laws are now permanent, and the landlords have to go back and get their 421A law extended in 2 years, and so we might have something to say about that, just say. Just a thought. So the vacancy bonus, which used to be 20%, and the longevity bonus, which was an additional increase if the prior tenant had lived there for 8 or more years, has now been reviewed. The Rent Guidelines Board has no power to issue increases for vacancy leases. And for those of you who were around when the Rent Guidelines Board, under the previous administration, issued core taxes for low-rent apartments would get higher increases, that power that the Rent Guidelines Board had to do that was taken away. So just a note about how the agency interprets law and how I might interpret law, and we'll see what the courts say. As I read the law, on vacancy, a landlord gets no increase. That's what the words of the law seem to say to me. However, HCR, in its new policy statement that came out today, says that upon vacancy, the landlord can take either a 1 or a 2-year RGB increase based on whether a tenant takes a 1-year lease or a 2-year lease. I think the ultimate question of whether HCR is right about that will be decided by the courts. But right now, people are going to vacate apartments that are where new tenants are coming in and getting vacancy leases in rent-stabilized apartments. The rents are going to be raised either by the 1-year or 2-year RGB increase because that's what HCR has told landlords to do. So it's really important for us to keep an eye on what the agency does and how it interprets the law. In some cases, the courts will listen to them. As I said, in my opinion, in this case, the law is pretty clear, and I think they got it wrong. Rent control. This was mentioned by Senator Benjamin, by Commissioner. So rent control tenants, the myth is that they pay the lowest rents in the city, that they have no rent increases, that all rent control tenants are paid $50 a month for 7-room apartments. So I know there are some rent control tenants in the audience, and I can say that was false. In fact, rent control tenants face some of the highest increases in the city because previous to the change in the law, rent control tenants could face up to 7.5% every year as long as HCR found their landlord eligible for an increase. Additionally, if fuel prices went up, rent control tenants would bear the burden of having to pay that increase, even though no other tenant in the building might see an increase based on those fuel prices. Now, the system is still in place. Landlords still must be found eligible to get an increase. If a landlord is found to harass a tenant, fail to provide essential services, have uncorrected rent-impairing services, the HCR will still find the landlord not eligible for an increase. But if the landlord is eligible for an increase, instead of 7.5%, the landlord will get an increase of the lesser of 7.5%, or an average of the last 5 years of 1-year rent guideline board increases. Just to give you a sense of the scale, if you take the last 5 years of RGB increases and do an average, I believe it's 0.75%. So for rent control tenants, their increase will have gone from 7.5% to 0.75%. That doesn't mean that if you're a rent control tenant, when you write your lease, you write the rent next month or this month, that you can calculate that on your own. That's going to have to wait until a rent order for the next increase that comes into effect. I do understand that some landlords have already taken off the fuel pass-alongs, and if you're rent control, my suggestion to you is you ask your landlords to do that because they might, and that would be good. Preferential rents are if you are paying less than the legally registered rent in your apartment, you have a preferential rent. It used to be landlords could take it away or add $50 or $100 or $200 at any time they wanted on lease renewal. At this point, if you are a preferential rent tenant for the life of your tenancy, as long as you and any successor lives in the apartment, your rent is going to be based on the preferential rent, which is great for a number of reasons, but for people who are otherwise eligible for SPRE or DRE, this means your rent should be frozen at your preferential rent amount and not your legal rent. Because for so many people who apply for SPRE and DRE and the preferential rents, they got no benefits from SPRE or DRE because the amount they paid kept going up while the legal rent was frozen, which gave them nothing. But now, Department of Finance should if you have a preferential preferential rent and you weren't able to get it because you applied, you should be eligible for screen injury, and you have a preferential rent and you didn't get screen injury because of your preferential rent, please apply immediately to the Department of Finance and get your rent frozen. If you were offered a lease renewal before the law went into effect, but your lease goes into effect after June 14th, you have a right to a preferential rent even if you signed the lease, taking away your preferential rent. If that has happened to you, there is a new fact sheet number 40, on the HCR website, and it gives this as an example. Print it out, hand it to your landlord, and tell him to fix it, otherwise file a case. If you are a preferential rent tenant, and you think your legal rent was come to in a way that made no sense, maybe you want to file a case to get your legal rent changed, because a lot of the legal rents were gotten to in an illegal way. Major capital improvements, and this is one of the places where I talk about a lot of changes in the laws being extraordinary. This is somewhat less extraordinary, but there are changes. They will have real meaning. They are not as far as we wanted to get to. They also are the place where HCR has been called upon to do the most work to figure out how the system works. So HCR must create a schedule of reasonable costs and shall set a ceiling for what shall be recovered. Have they created that schedule yet? No. How are they processing applications that are before them without the schedule, which is in the law that went into effect June 14th? I'm not really sure. They're supposed to, but there is no schedule. Payback period. That is the period of time after which the landlord gets all of his money back. People used to talk about 184 and MCIs. They used to be 7 years. In 7 years, the landlord got all his money back. And then in 2015, it went to 8 or 9 years, depending on the size of your building. It's now gone to 144 months and 150 months. So it's gone from 96 months to 108 months. The annual cap, which used to be 6% for rent-stabilized tenants in New York City and 15% for rent-controlled tenants and rent-stabilized tenants outside of New York City, is now 2% for everyone. This will lower people. There will be increases, there will still be MCIs, but people won't be faced with 6% or 15% increases every year. When the tenant who's getting the increase, if they leave during the phase-in of the increase, the next tenant will get the full increase. No more retroactive charges. It used to be if you bought an MCI for a couple of years, you would then get your MCI increase, and your landlord was entitled to this increase from the moment he filed. So at the end of paying off all the money that was permanent, you then had to pay all the money from the moment he filed to the moment the increase was filed. And so your new increase was phased in, and you were still paying more money because you had to pay back the landlord for this permanent increase, which makes no sense to me. That's all. MCIs expire after 30 years. They're now called temporary MCIs. How are they going to take off the MCI increases, which will be in time with all the other increases of apartment space in 30 years? I don't know. If you ask me that question, I'm going to say I don't know. I don't know. It doesn't totally make sense to me, but HCR is going to have to figure it out. MCIs, they've changed the definition of MCI a little bit. MCIs must now be essential for preservation, energy efficiency, functionality, or infrastructure of the entire building, which includes heating, windows, plumbing, and roofing, but not operational costs or unnecessary cosmetic improvements. What does that mean? I'm not sure. I truly believe that there will be no more terracotta tiles, right? Those are gone. Right? But do I think that MCIs will be limited to heating, plumbing and roofing? I'll know. I mean, this is one of the places that HCR will determine what is allowed as an MCI and what is not. I am hoping this language will limit it. I'm hoping fancy new lobbies will no longer be considered necessary for an MCI because I think they're cosmetic. I'm hoping that the robots that are in Lefrak City roaming the buildings for security will be considered cosmetic, but who knows. Work inside individual apartments is no longer eligible. There were landlords in parts of the city who would take over a building and they would take out the kitchens and bathrooms of the tenants in place. And those tenants would have to be without kitchens and bathrooms for a period of time, making their lives miserable. Did they still have to pay rent? Yes. So what happened at the end of that absolute misery? Their rents went up because the landlords were allowed to get MCIs for that. That is no longer allowed. It's free. If the building has more than 35% of rent-regulated tenants, no more MCIs. Sorry, less than 35% rent-regulated units, no more MCIs. So I'm going to get this question. I'm going to tell you, I'm going to like the spoiler alert. Does this part of the law apply to pending MCIs? I have no idea. My suggestion is there's a really good argument that it ought to, and people should be saying it ought to, and to the extent you're represented by counsel, or even if you're pro se, you should be going to HCR and saying, my building has less than 35% rent-regulated units, and therefore under the new law, there should be no more MCIs for rent-regulated tenants. Please make that argument. Ultimately, that is going to be first decided by HCR, and then we'll sue, and then it will ultimately be decided by courts. I don't have a lot of faith in what HCR will do. I promise you they will be sued. Buildings must be clear of both B and C violations. Increase goes into effect the first of the month after the date of mailing plus 60 days. And HCR must audit and inspect 25% of MCIs. How are they going to do that? I don't know. I really think that this is like a really good place for people who've worked with HCR and had frustrations with HCR come up with suggestions on how they do it. You know, they're supposed to listen to the public, and it's a good place for them to listen to us because we know which buildings are making it and which ones aren't. This is just an example so you can understand what the math looks like. Under the old rules, you might see an increase of $104. That's with the old payback period. And that increase, if you have a tenant who is paying $1,000 a month, they wouldn't get the whole $104. They would get $60 for the first year, and the other $44 the second year. Now, the increase because of the longer payback period will go from $104 to $69. And the increase will be spread out not over 2 years, but 4 years because of the 20% increase. Now, there's this slight part of the bill that says that if you are in the middle of a phase-in, next year you will now get a 2% increase. So in the example in the first part of the example, if this year coming up was year 2, your increase would not be $44, it would be more like $20-something. So that person under this example would, in the future increases will be lower. The law didn't, unfortunately, roll back anyone's rents. IEIs. IEIs are capped at $15,000 every 15 years. Landlords can make 3 of these IEIs, but all told, the landlord can spend or get compensated for no more than $15,000. The rate of increase has gone from 40 months or 60 months to 168 months and 180 months. So that means that the most a landlord can get for an IAI, depending on the size of the building, is $83 or $89 over a 15-year period. Now, I've seen IAIs for over $1,000. I don't know if any of you have seen buildings, apartments that were completely, renovated to the teeth, and then the landlord jacked up the rent to some unbelievable amount. That will no longer be allowed. And we're really hoping that that means that the incentive for pushing out long-term tenants will be lessened. It won't go away. But we're hoping the race to push people out and then do construction abuse will be lowered, and people's lives will be just a little bit better. Owner use, landlord gets 1 unit per building. So the McMansions, when landlords bought buildings, cleared them out and made themselves a McMansion, no longer allowed. And there's an entirely new system of how the statute of limitations works. We used to talk about the 4-year rule. Now the base amount you can look back is 6 years, unless if you see unexplained jumps in the rent going back longer than 6 years, you can go back saying that the rent registrations are unreliable. And in that case, there's no limit to the amount of time you can go back. And these are the rent laws. But as was mentioned so much, the Housing Stability and Tenant Protection Act is more than the rent laws. There are a lot, we did not get the cause eviction. I know I once argued with someone who owned a condo that she should be under the cause eviction and not be able to evict a tenant for no cause, and she called me a communist. Okay, I still think the cause eviction is the right thing to do, is the moral thing to do for unregulated tenants. Landlords should have a reason if they're going to evict you from their homes. But it was the effort we brought from across the state talking about how many people were harmed by what goes on in unregulated apartments that did lead to laws that got passed to talk about things beyond the rent laws. Late fees. Landlords can charge $50 or 5% of the monthly rent, whichever is lower. There's an entirely new scheme for the security deposit law. There's no more than 1 month's rent. The landlord can withhold security deposit only for damage to the unit above wear and tear. What does wear and tear mean? I'm not sure yet. Sorry. It's just not a term of art. We're going to figure it out as we go along. They can withhold it if for non-payment of rent or non-payment of utility charges to the extent that the tenant is obligated to pay utility charges to the landlord, and moving of the storage of the tenant's belongings. There's an entirely new scheme of inspections that starts before the tenant moves in, so they can document what the apartment looked like before they moved in. If before the tenant moves out, they have a right to another inspection with the landlord, so they're on the same page of what the apartment looks like, plus get notice about anything the landlord's going to complain about and can fix it themselves instead of relying on the landlord. And then within 14 days of the tenant moving out, the landlord has to either send a written notice detailing why they're not returning the security deposit or returning the security deposit. And if that 14-day notice isn't given, the landlord has no defense in small claims court for not returning the security deposit. Yeah, that's great. Retaliatory eviction. Basically, retaliatory eviction is if you, it says that if you complain to your landlord about doing repairs and your landlord's response is to evict you, you can claim retaliatory eviction. This is a law that we don't use a lot in New York City. We should use it a lot more. This law was strengthened, and if they find that your landlord retaliated against you, they have to offer you 1 more year lease renewal. So to the extent that you're being evicted complaints to your landlord or the landlord or the super or the managing agent, it may be worth it to make this argument in court. Notices of non-renewal or rent increase. One thing about this section, it goes into effect October 12th. So it's currently not in effect. Landlords had 120 days for it to learn about it to go into effect. Notices of non-renewal or rent increase of more than 5%. If the tenant has had a lease of less than a year, occupying the apartment for less than 1 year, they get 30 days notice that the landlord isn't going to renew their lease or their tenancy, or that the landlord is going to raise their rent by more than 5%. If you've lived there for more than a year, then you get 60 days notice of non-renewal of tenancy or lease, or 5% increase in rent. And if you've lived in the unit for more than 2 years, you get 90 days notice of this. Once this law goes into effect, it's for all the leases that come due after October 12th. So if your lease is up, let's say October 31st, and your landlord hasn't given you the proper notice, he can't say, I'm not renewing your lease. He can't say, I'm increasing your rent by 5%. So what if he failed to give you the increase? All it does is it delays things. It says, landlord, your time starts now. So if your lease is up October 31st, if your landlord thinks that he's going to tell you September 30th that you have to move, you need to go back to him and say, no, you're supposed to give me 90 days notice of this. And then the landlord will give you 90 days notice. The purpose of this provision is to give people time to plan. That's for everyone. This is for everyone. It shouldn't really be an issue for rent-stabilized tenants because the landlord can't not renew your lease, one. And two, tenants get notice of lease increases 150 to 90 days beforehand anyway. So it shouldn't affect rent-stabilized tenants so much because they already had notices for these things. It should affect everyone. The law was written that it affects everyone. Again, it would be odd for a rent-controlled tenant to be seeing a 5% increase, an over 5% increase in coming years, because there hasn't been more than a 1% or 2% increase for a very long time. So taking the average of the last 5 years, it's going to be a long, long time before rent-controlled tenants ever see a 5% increase. If a tenant breaks a lease during the lease term, after the tenant breaks the lease, the landlords have a duty to mitigate by renting the apartment at the lower of the market rent or the tenant's last rent. It used to be that if you broke your lease in the middle of the lease term, the landlord could sit on his hands and just get the rent from you. Can't do that anymore. There's a ban on discrimination based on tenant screening reports. Unfortunately, there is not an enforcement mechanism other than through the Attorney General for this provision, and we'll see how it works. Application fees for new apartments. Bars or limits application fees prior to rental, including background checks, to $20. I'm sure many of you have read articles about how landlords are saying, I don't need to follow this law because I'm a landlord and I should follow the law. So this provision at this point doesn't have an enforcement mechanism. It would seem to me if I were a legislature and I passed a shiny new law that would agree with my constituents and industry said, I don't care, so what? That I might want to go back to when I was called back into session and fix this. Non-rent fees are excluded from non-payment cases. When they talked about fees, they're really talking about things like AC fees or late fees. Rent demands must be in writing and must give 14 days notice. Multiple court deadlines are longer. Notices of eviction are 14 calendar days, not 5 business days. In certain cases, the court has the power to give a tenant up to 1 year to find a new apartment. What the language in the statute And it used to be in New York City, tenants could get pretty routinely up to 6 months. But this, another 6 months is a pretty important win that we want. And in breach of lease cases, when you ask for a breach of lease, things like you have a washing machine and your lease says you can't. You have a dog, the lease says you can't. Those are things like when the landlord's saying your lease says you can't do X and you've done X, that's a breach of lease case. Tenants now have 30 days to fix whatever the complaint is. Get rid of the washing machine, sadly, get rid of, adopt out the dog instead of 10 days. And then, I'm done with this. I want to say a word about the lawsuit, the landlord's lawsuit. And So, don't think that the landlord's lawsuit was brought by the changes to the rent laws. The landlords 18 months ago went to a hoity-toity, very expensive firm with a partner who's argued a lot of cases in front of the Supreme Court and was in the Reagan administration, and said, figure out how to get rid of the laws. And so the law they were talking about at that point was not the changes to the rent laws. In the lawsuit, they complained that poor landlords, they have to offer tenants renewal leases and give succession rights to people's families. Really poor landlords. They don't actually say how any of this has harmed them, which is actually part of what you do when you bring a lawsuit. They wrote 124 pages of complaints about how sad their situations are. I will tell you, in general, being a tenant attorney, the courts aren't our friends, but this issue was settled decades ago. And it wasn't just settled by New York Court of Appeals cases, it was settled by the Supreme Court. The last time that a rent control case was heard in the Supreme Court, it was 2005. And this wasn't like a Roe v. Wade situation where it's 5-4 decisions for decades. No, this was a 9-0 decision, right? And who was part of the majority? Justice Scalia and Justice Thomas, right? So you got the right wing of the Supreme Court on the tenant side. So if they win this case, and then they tried to get the rent laws overturned in 2011, and the Second Circuit laughed them out of court. That's our appellate court. So if the lawsuit wins, will it end rent regulation? Yes. But in my opinion, will end all regulation, going back to child labor laws, because there's no substantive difference between having regulation on business and regulation on residential real estate. So why are they doing this? Well, they think there have been enough crazy people appointed to the courts that they're going to get this overturned. They're wrong, right? They're wrong. But the more important reason they did this is they have too much money. Right? And you have too much money. There's only too many, so many yachts you can own. Right? And so many houses all around the world. At a certain point, you just need to burn a whole bunch of money. And that's what they're doing with this lawsuit. Now, I will tell you that even so, I have full faith that the city and state is going to defend this lawsuit. I still think tenants' voices are important when a judge is considering tenants' lives. So the Legal Aid Society and the Legal Services NYC have asked the court's permission to intervene into the lawsuit on behalf of community voices for tenants and neighbors and the tenants of New York City. We are hopeful that the judge will say yes. We still think we're going to win, but it's better to win with the tenants as part of the case than not.
So, Ellen Davidson, Scalia, Thomas. are lots of people to follow up with. And depending on where you live, you may already know that there are certain groups who do clinics on housing issues, different weeks, different days of the week. So, sorry, we're not going to take personal example questions, but we have an enormous number of questions. I suspect that most of these questions will be addressed to Ellen Davidson, but I invited all our colleagues back up, and I would put money on Brian Kavanagh knowing a lot of the answers. But as you've already seen tonight, this is a really technical set of major changes to housing law. And as Ellen said correctly, on some issues we're still waiting for HCR to interpret, and then for the legislature to revisit, was that what we meant, or did they misinterpret? We've already confessed, a number of us. We did an enormous amount of change fast, and we may need to do technical changes and corrections as we go forward. And we've already told you, we don't think we got everything done. So some of your questions, in fact, I think will highlight for us as legislators where we still have to go. So just my very talented staff, and thank you all you talented staff out there. We're very helpful in trying to put these into groupings of the topics. So starting with more general questions. And I'll just look at the panelists, and then anybody who feels like they want to take a jump in, feel free. Are there any parts of the new law that deal with nuisance issues? No. Well, we did pass a separate law.
I mean, the only thing I can think of that deals with nuisance is that some of dates for how long cases take, that includes holdovers. If you're being evicted for a nuisance, the type of case you're seeing is a holdover case. And so there are some lengthening of periods of time in order for the case to start, in order for you to answer, that were part of the new law, but nothing specifically on nuisance.
If my landlord is proposing to demolish the building, do I have more protections under the new law?
No. To me, that remains the laws around demolition of buildings remains an area, a loophole in the laws that needs to be closed. Because now that landlords can't use all the other loopholes that we closed, there are still, we have to look for where they're going to try to open those loopholes and close those.
I actually carry legislation on that would require landlords who demolish buildings, because we've had some inadvertent demolition in Chelsea. The landlord would have to replace every unit of rent-stabilized apartments that he or she destroyed.
Thank you. Put on your list for things to get done. Do eviction and non-eviction conversion plans still exist?
Eviction plans no longer exist. Non-eviction plans exist, but instead of getting the approval of 15% of bona fide tenants in order to get to the conversion of rental to co-op, the non-eviction plan now requires 51% of bona fide tenants.
Is there anything that's changed about the rules around receiving rent registration notices?
No.
So if you haven't gotten one, what should you do?
Complain to HCR.
Okay. I'm going to give you the DHCR contact information. Okay, sticking with general. Can we explain more about the changes to owner use evictions?
So the changes to owner use evictions is that it used to be like a landlord could get as many apartments in one building for owner use. Now you can only get one unit in the building. There's also more protections for tenants who lived in the building. It used to be that you couldn't be evicted for there's a new provision allowing tenants to sue if it turns out that it was all a lie and fraud to go after the landlord for a fake owner use.
What happens if a tenant leaves they are a renter within a co-op and they have rent stabilization, but now they're leaving? Does the owner of the apartment or the co-op, or if they have control, have the right to bring that apartment to the free market, or does it have to remain stabilized?
If a rent stabilized tenant has been living in a co-op that was converted, I think, it's not my area of the law, but my understanding is when that tenant leaves, that apartment becomes a co-op.
I thought I'd tell the rest of you in addition to telling you. I think under the new provision, so if it is rent stabilized under a conversion that happened before this law was passed, in most cases it'll become, the rent stabilization only lasts as long as the existing tenancy. Pretty certain that under the new law, we say that if there's a conversion and the resident of that unit is rent stabilized and declines to purchase, the unit remains rent stabilized indefinitely, not just for the duration of that tenancy.
All right, I don't love that answer, but there's it. All right, is housing court going to work better for tenants under the recent, sorry, I'm having a little trouble with my reading of handwriting. 1 second. Hold on, we'll go to another one and I'll practice and I'll come back to that one. It's not you, it's just my handwriting sometimes. Do these changes apply to landlords who are hospitals? Because there are not, or I'll just say not-for-profits. There are not-for-profits who own buildings with rent-regulated units in them. And sometimes their employees are provided apartments and leases, but then assume that they will leave if they no longer are working for the entity. I would actually say hospitals, universities, other not-for-profits actually do own buildings that have rent-regulated units.
Sure. So there were changes to the law. So non-for-profits are depending on where you are located in the law, they're exempt from the rent laws. However, there was an exemption to the exemption put in the statute for not-for-profits who house either formerly homeless or to prevent people from becoming homeless. I actually would have to look at the law to see how it affects hospitals. I don't know off the top of my head. I do know that the provision was mainly in response to non-for-profits who were renting to people who were supported housing or to people who were formerly homeless, who were losing those units when landlords, when buildings that they were renting in were in neighborhoods that were becoming hot. The landlords were suddenly evicting all of those not-for-profits who were mission-driven and trying to house homeless or people who had needed supported housing. And so there was a change in the law to protect both those tenants and those not-for-profits. I don't know that hospitals fall into that.
So we don't talk about the new laws affecting tenants' relationship with landlords. Does any of it apply to the relationship between a tenant and a subtenant? application day. So Brian Kavanagh mentioned that the rent stabilization is an important part of affordable housing. Is the definition of affordable housing being changed to include non-means tested units? Prior to these laws, affordable housing meant means tested. Well, in rent regulation, we don't have means tested.
Yeah, so I,
Well, let Brian answer the thing. Is that all right?
Yeah, sure. So, I mean, there was a very limited income test in the rent laws. There was this provision that if your household made more than $200,000 and your rent exceeded the deregulation threshold, you could be pushed out of your home and the unit would become deregulated. That was repealed in this law. I think that, I mean, a definition of, there's a lot of discussion about what a definition of affordability means. There are many units that are being built with public subsidies that house people who make pretty generous incomes who are middle class. There are obviously others that are targeted at people making very low incomes. I think the important thing is that we have a range of policies that ensure that the people who actually live here and make the incomes that people make here can afford to live in their communities and can afford to live in communities that are economically diverse. And rent regulation has been the thing that has done that over a long period. But obviously, if you're talking about expending taxpayer dollars on a program, you'll typically say, well, we're spending this much money on the units and we're making them affordable for people at a particular income and a particular rent. And so, you know, the word affordable might mean different things in different contexts.
and can I just, as someone who represents people who I think most people in the room would agree are low income. In fact, we represent people who are, by federal definitions, very low income and extremely low income. These so-called means-tested programs often harm my clients because if they don't get the paperwork correct, it's not like the landlords aren't trying to get them out because they want to get them out. And so means testing, to my mind, I mean, there are so many of our clients who've lost free injury, not because their incomes were over $50,000, but because they didn't fill out paperwork perfectly. And so, you know, to the extent that the idea behind rent regulation is that we're going to make your life miserable until you move out of an apartment because you haven't jumped through every hoop, that is a kind of landlord way of looking at it.
I just would add, so we repealed this provision for so-called high-income deregulation. We lost about 6,500 units to that. It was mentioned before, we lost nearly 300,000 units to the deregulation provision. But one of the reasons we repealed it, first of all, a family making $200,000, that's not in our neighborhoods a very rich family, right? You have a few kids and you know, make this two-income family. But beyond that, we were concerned that given all of the other loopholes that have been repealed, landlords would use that provision. There's kind of an onerous process where the landlord can require you to document your income and send notice to you. And if you don't respond, they might move to evict you. So we thought that landlords might use that in an abusive way to try to deregulate you. And so we took it off the books.
Okay, so everybody talks a lot, and every office knows about people trying to go back and check the records whether they've been overcharged. There weren't regulated apartments, and again, HCR, and you may need a lawyer to help you, and it's very important. This question is specific to, what if you're a rent control tenant and you believe you've been illegally overcharged? How would you go about checking that, since until we changed the law, it was mathematically such a complicated process? And are there the same kind of, is it the same kind of process for the HCR? Or is there another approach?
The answer is that you go to HCR, you ask them to see your rent records. I think there's a way to do that. I haven't done it in a really long time. And then you would need to check whether the increases are connected to the rent orders that happened, either happened or didn't happen all the years. So I mean, I think you can go to HCR and online there's a way to ask for your entire apartments, the files connected to your apartments. is not about the changes to the law. That's how they were able to file a 124-page complaint a month after the law changed. They are literally complaining that the city council has every 3 years renewed the rent laws. That is the gravamen, that's the heart of their complaint, is that since 1969, the legislature has continued to renew the rent laws because they think that looking and asking the Census Department to do an analysis of whether or not we have a housing emergency based on a vacancy rate, even though that's what the law says, that's not the right way to do it. They are smarter than all the legislators and all the employees of all the governments and all the tenant attorneys, and they know better.
That was sarcasm.
Sorry. So the answer is, there will be no, if they win, there will be no more rent loss.
We'll have another.
It's not about, the only new thing that they mention as being gross and terrible for them is the owner occupancy. They don't mention anything else in the lawsuit, as far as I can tell. But as I said, what they're really offended by is that tenants have a right to a renewal lease, and they mention that law.
And just, I guess so the law, the state statute used to expire every few years and needed to be renewed. And we've now eliminated that, so it expired in 2011, 2015, it was scheduled to expire in 2019, June 15th this year. It now doesn't expire. It is still the case that, the rent laws are justified because there's a housing emergency, and housing emergency is defined in the law as a low vacancy rate below 5% in the regulated housing stock. That it is still the case that localities will make that determination. New York City will periodically make a determination that it is still a tight housing market, and therefore the rent laws are still justified. That hasn't changed in law. It's just that 2, 3, 4 years from now, the state legislature doesn't have to act. Otherwise, the whole thing falls apart.
And how amazing that is that they're permanent, because you know that the rent laws are often renewed based on other issues, extraneous horse trading up in Albany that had nothing to do with protecting tenants. So, congratulations. The permanence is a big deal.
Building the case involves developing a basis Yeah, no, nothing was changed. Yeah. So to be determined through regulation?
Yeah. I mean, maybe it's a matter of pushing HCR to say preferential rent. It's preferential rent is the rent for the life of the tenancy, but security deposits is in a different part of the law, and so how those two things interact is not totally clear. But again, I think it's a good thing to put on our list of regulations we want from HCR.
If I'm a, yeah, here's the thing in front of us. If I'm a market rate tenant and my lease ends on October 1st, if I did not sign a new lease, what happens? Am I going to a month-to-month basis? Rent increase?
If you're a market rate tenant who doesn't have a lease, in order to be a month-to-month tenant, you actually have to pay rent. But to the extent you do pay rent, then you're a month-to-month tenant. And if the landlord wants you to move out, after you become, if there's just no lease, there's been no conversation between you and your landlord, there's just no lease, and you're paying, and you suddenly become a month-to-month tenant, the next month, to the extent the landlord wakes up and said, oh, I meant to tell her that she needed to move out, now the landlord's going to need to do the new notice provisions because it's after October 12th.
So, MCIs in the building are only applied to tenants who are rent regulated, not market rate. Is that legal?
Yeah, because the reason it's legal is that the landlord has an ability to raise the rent of the market rate tenants, sort of outside of the rent regulated system. So the landlord has the ability to go to the rent regulated tenants and say, this new improvement cost, you should pay me another $200 because I did whatever. And so that's between the landlord and the market rate tenant. The rent regulation tries to mimic market conditions in a lot of different areas, and this was its solution to what happens when landlords make improvements where in other circumstances they'd be allowed to increase rents.
I think this was addressed earlier, Ellen, but it's not here. So for people who are in the process of appealing MCIs, is the review of the MCI based on our new law or on the old law?
I mean, I think it's worth it to make the argument that they should use the new laws in reviewing the appeal. I think it's a good argument. I think I would feel very comfortable making that argument on behalf of my clients. If you're going to ask me to look in a crystal ball to decide, like, is that going to be accepted by the courts, I don't know. But I think as many people should be making that argument as possible. But I don't know what the ultimate end of that argument is.
I need to do the discussion of MCI rollback. How does one get this? Does the tenant have to ask? Is there a form the landlord automatically has to provide? Is it a credit? Is it a refund?
So there's no rollback. Rollback doesn't exist. What there is that if you are in the midst of getting an MCI increase that meant years into the future you are going to see 6% or 15% increases, instead of the 6% increase that you would be expected to pay in your next lease renewal, you will now see a 2% increase. But there is no refund. It is there's no refund. There's no credit you're getting. It just means that the increase that you are facing may be less. And you will, my memory of the new fact sheet that was issued today on the HCR website is that it instructs landlords who are in the middle of phasing in an MCI increase to tell for the increase to be 2% at the next time that the tenant would have seen that increase as opposed to 6%.
So this question isn't something you said earlier, but I just want to highlight, you were highlighting Track City say that robots in the halls are an MCI, and I, just for the record, a robot probably has a 2-year lifespan. That is not a major capital improvement. It's 30 years, so we're going to win that lawsuit.
Yes, although I will tell you that previously, it's between buildings, one of them like tried to get, Jamani Williams was running for Lieutenant Governor, and he got caught by one of them who didn't want to let him move go around the buildings. But they won that case previously with HCR. Track City tenants are getting an MCI for the robotic system of security guards.
This is one of the dangers of artificial intelligence. I just want to point that out.
Right. But the actual question on the card was, if a landlord is charging you a fee for replacing an appliance, can they collect that forever?
So, I mean, the question to me, are you rent regulated, are you market rated? If you're market rated, it depends on what your lease says. And you should read your lease, what it says about fees for replacing things. If you are rent stabilized, you shouldn't be paying fees for replacing anything in your apartment. Should not. So, you are only supposed to pay rent if you are rent stabilized tenant. You may have to pay a fee for use of air conditioning. And there's a system, like you should go on to the HCR website and look up air conditioning. There's a whole fact sheet about air conditioners. They can charge you a fee for the use of the air conditioning as it affects the electrical system in the building. They can't charge you for the new air conditioner versus the old air conditioner. It's about electrical needs of the building. But there's a very long fact sheet on air conditioners on the HCR website, and I would suggest taking a look at it.
What is the HCR website? And it's on the piece of paper that we gave you with all the contact information. And if not, Brian's looking it up.
Yeah.
It's on the piece of paper that we gave you with all the contact information.
But I usually Google New York State NYS HCR, or you can Google DHCR, which are the same thing. And that's what I would
The Cell Signature Bureau's terrible site. It's easy to find.
So, if you need a new refrigerator and you want a brand spanking new refrigerator, the landlord can ask you to sign an agreement that of an individual apartment, that's considered to be an individual apartment improvement. If you have a refrigerator that's broken and the landlord offers you a refurbished refrigerator, one that works but that is not new, maybe you don't pay anything. But if what you really want is a new refrigerator, the landlord is allowed to take an individual apartment improvement for that. To the extent that you agreed in writing to an individual apartment improvement that you previously got, that is a permanent increase. The landlord can take either 1/40th or 1/60th of the cost of that improvement forever. In the future, to the extent you want a new refrigerator or a new stove, again, you still have to consent to it in writing, but the cost of it would be either not 1/40th of the cost of the new refrigerator, or 1/168th or 1/180th of the cost of the
we have seen that pattern over the years quite a bit. So how do our new laws help us with that?
I mean, I think to the extent that you're living in a building and you see someone move in, it would be a really great way of breaking the ice with your new neighbors to make sure they have a rent-stabilized lease. Like, we're going to have to keep track of it, and then how, I mean, I think that there are probably ways through the use of computers, which I think you guys gave the agency money to computerize their system, and to the extent they finally did that, there should be ways for them to figure that out. And there are people in the city who understand how to scrape data and have been doing a pretty good job of figuring out, like, buildings that were J51 were deregulated, and so we should maybe talk to them about starting to keep an eye out for that sort of thing.
Yeah, just to add, it's a lot easier to track that kind of issue in a world where units cannot be regulated, right? Under current law, there's a certain number of units that are regulated last year that are legitimately no longer regulated. So in a world where everything that's regulated now is supposed to be regulated next year with very minor exceptions, it ought to be easier for HR to keep track of this. And we didn't give them money for 94 new full-time equivalent positions for rent administration and tenant protection.
So lots of questions relating to, obviously, many in real estate are very unhappy about this. They're suing, they're threatening. What happens, and again, I wasn't a big part of this question, what happens if the Republicans take the governorship, Senate, and the Assembly, and they reverse these laws? So they can, but I would argue a couple of things. One, not on any of our lifetime, that's going to do this statistically, but two, participation is so crucial in elections, and why many people can be very cynical about their elected officials. I get it. But if you don't participate, you just get worse. And you want to make sure that you are electing people who represent your concerns and your interests, and getting big money out of the political process in Albany is really crucial to protecting voters' concerns, because what we saw for decades was a handful of very wealthy corporations paying for the Senate majority to remain Republican, to make sure these kinds of laws did not pass. And if we go to in my opinion, I think I share quite a few of my colleagues' views on this, if we go to a public finance, low donor match model of elections as the city of New York does, we are far less likely to see corporate control of our democracy. There's a simple math assignment. So we already you say, why should government funds be used for elections? And I say, well, actually, when government funds in New York State are used for elections, I can add up how much of your state budget dollars are going to special interests, and it's 100 times what we would ever pay for a publicly financed campaign system. And so we would have so much more money for the things that really matter to people if we weren't obliged to a certain universe of specialists. So,
I
right.
could just add one thing briefly. I mean, it is true that if all three, if the Senate and the Assembly and the governorship were taken over by somebody who was opposed to the drug laws, they could undo it. One of the big implications of making this permanent is that it does take all three. For many decades, it has taken all three of those entities to keep the laws in place. Now it would take control of all three to remove them. So even if you think, maybe a Republican who's opposed to, whose landlord friendly is going to win the governorship, they can't undo this law unless they get the agreement of the Senate and the Assembly and the Senate. That's the implication of doing it, of making it permanent.
And this is also a voter education point, right? I mean, I can't tell you how many times I hear from people, oh, it doesn't matter who's Democrats or Republicans, you're all no good, you all don't do anything useful. And this mindset is continuously sort of fed into the environment. Even by some of my colleagues, some of my Democratic colleagues, we say, oh, we beat each other up all the time. Let's be very clear. The difference between the Senate Republicans in control of the Senate and the Senate Democrats has been monumental. And I think we need to state that and educate people so that they know there is a real difference if you have Republicans in control of any branch of the government in New York State or when you have Democrats in control. And we got to be clear about that and educate people on that so that they know it really matters and that will keep the right people in office.
Does the fuel pass through and June 14th, 2019 when we pass the law, or January 1st, 2020?
Well, I've been telling tenants who I talk to that it's June 14th and to not pay it anymore.
I mean, I think once you go to, I would go to your landlord and say, take the fuel pass along, charge off, and then file a case with HCR if they won't do that. So, in the end, HCR is going to make this determination. I think they're going to, I'm hoping with the fuel pass along, they'll do the right thing. People need to start complaining to HCR to agitate them to actually come out with the smart rules so everyone is following.
And again, then there was another question about, and I believe that Brian Benjamin answered it before, and Ellen went over a little bit. Yes, there will still be rent increases in MCIs, minus the pass-through of the fuel costs, but the calculation will be an average of the last 5 years of what the rent control board here in New York City did. So you probably need to wait to DHCR come out with a pronouncement about what that amount will be for the next lease period. Or it's going to be the rent guidelines board comes out with the pronouncement.
Right guidelines more.
Well, so it's going to be, so the landlord still has to apply to get a rent increase, right? So instead of your landlord applying and you getting a 7.5% increase, when your landlord applies, the new formula that HCR will be considering will be looking at the last 5 years of 1-year increases from the rent guidelines board. And so you'll get rent control tenants get increases based on applying for, your landlord applying to HCR for an order. And so you'll see the change in those orders.
And there are a pile of questions specifically for the DHCR commissioner. So as we said, we're going to submit them to her, and she's going to respond, and we'll put that up and available on the website. Okay, we talked about landlords are now refusing to do some repairs and improvements, saying it's because of the new laws. I'm sure that's probably true in some places.
That was what was publicly stated, at least initially, by the owners and operators of Stuyvesant Cooper Village, Stuyvesant Cooper Village. But they backed off on that and said that they're proceeding with maintenance and will be renting apartments within weeks.
Yeah. So I just want to say that there's nothing in the rent laws about repairs. The landlord's obligation to do repairs is found in a city law called the Housing Maintenance Code, and that has not changed. So the landlord's obligation to keep an apartment in good repair, your landlord can complain all about the rent laws. The city will still find housing code violations in your apartment, and that housing maintenance code has not only still exists, but in some areas, including a great new law about asthma and the underlying conditions that cause asthma, including leaks and pests, has even been strengthened. And so to the extent your landlord has decided that he is going to war with not only the New York State Legislature and the governor, but the New York City and HPD, he's not going to win that war. So I just call 311 when your landlord's doing conditions, I suspect stress than there may be going on in actual buildings, because landlords are really trying to create a level of fear, partly to get back at you for, pushing for better laws for you and your family. And one of the ways they're getting back at tenants is like basically threatening them every day in the paper. So some of this is, they can't make your lives miserable as much as they used to because it doesn't make them as much money. So they're going to make your life miserable by making you scared. So don't believe everything they say. And to the extent your landlord is overseen, like if your landlord has gotten $1 gazillion from the city to keep your development so-called affordable, maybe you shouldn't be threatening the rent laws. That's exactly what happened with this guy from Peter Krueger. I'm sure there are other landlords who are taking tax breaks who are pretending that they're hurting, and maybe we should be making complaints and telling stories about them. One of the landlords in the lawsuit is a 421A landlord a J51 landlord who illegally deregulated his units. So, it's amazing how many landlords who've been doing illegal things feel no problem with going to the press and complaining. And we should be shining spotlights on them.
All right, I'm just going to do two more because it's 8:30 and we're told we have to get out of this building by 8:30. So this is not the real estate question about the application fees that has been in the newspaper. This is, if you're a real estate broker, can you collect more than 1 month of a fee from a client renting from a condo? So it's a rent-regulated unit that's actually owned by a private owner within a condo. So can a real estate broker collect, because they're calling it a fee apparently, instead of security deposit?
This is a fee for a new tenant, presumably for a new tenant moving into a unit owned in a condo charged by a broker.
Assume the question was meant.
So this is one of these areas where there is some uncertainty. So initially, the law says that you can't charge an applicant, a landlord can't charge an application, and a landlord, lessor, or their agent cannot charge an application fee. The law says that's not just for rent-regulated tenants; it's across the board. What has emerged in the press is that brokers, in many cases, are charging substantial fees. The Real Estate Board of New York, which is the biggest industry association and represents a lot of the big brokers, has advised their brokers that they think it would be imprudent for brokers to be charging application fees given the new law. But some brokers continue to charge them. The Department of State has a board that oversees brokers. We are trying to figure out whether they will clarify how they interpret this law for brokers. This may be an area where we need to do further clarification in the law, but we're not sure how it's going to play out. It is clear that a landlord can't charge you a fee, an application fee, and they can't charge you more than $20 for a background check fee, and they have to actually prove to you that if you ask, they have to prove to you that you spent the $20 and paid it to a third party if they're charging you for a background check.
All right, so there's a couple of questions that are from landlords, and it's true, not every landlord out there is a huge landlord with enormous amounts of money. So these seem to be specific to if somebody moves out after exploring what options you might have within city